Thank you all for coming and joining us this afternoon. Welcome to the Deason Center Student-Centered Programming Series, Deason Discussions. This afternoon's presentation features Federal Public Defender Shawn Nolan discussing a very relevant topic, the death penalty, the pandemic, and future practical challenges. For those who have not yet met me, my name is Kenitra Brown, and I am the staff attorney and engagement coordinator at the Deason Criminal Justice Reform Center at the Edmund Detman School of Law. The Deason Center was established in the law school in July 2017 under the direction of Professor Pamela Metzger. The center brings a stats and stories approach to criminal justice reform. We use stats to emphasize the stories of real lived experiences of justice-involved people to make compelling cases for criminal justice reform. We tell these stories through research, education, awareness, and advocacy. While our primary areas of research concern prosecutorial discretion, public defense, and small tribal and rural criminal justice systems, our engagement agenda recognizes that we don't and can't do our work without recognizing the expansive mission of transforming the criminal justice system and other structural systems it interacts with. And so it includes conversations about salient criminal justice issues and the national or public discourse. Given the current climate, we want our Deason discussion series to not only engage law students as future lawyers in these important discussions, but to include other students and other interested members of the university communities. Lawyers are change makers, but everyone has a role to play in learning about these topics and applying these lessons to their daily work and discourse. So please listen to learn, be respectful and thoughtful, and be mindful of your comments in any public forum. I'd like to formally introduce our guest. Mr. Shawn Nolan is the chief of the Capital Habeas Unit and the Federal Community Defender Office for the Eastern District of Pennsylvania and Philadelphia. He has been a public defender for 31 years, since his graduation from Temple University School of Law in 1989. For the majority of his legal career, Shawn has exclusively handled capital cases. In 2002, he began work in the Capital Habeas Unit. He was promoted to Chief of Unit in February 2014. He currently directs the largest capital habeas unit in the country. The CHU handles capital post-conviction cases in various jurisdictions around the United States, but he's also lectured nationally and locally about capital habeas issues and Guantanamo-related litigation. Please welcome Mr. Shawn Nolan.
Thank you, Kenisha. Good morning or good afternoon, everyone. It's nice to be here and nice to see you. So, when I was asked to do this, one of the things I said is, well, I'm happy to do it, but it's not going to be a two-sided presentation. And we laughed a little bit about that, but because what I do and what I've done for so long is represent people on death row. I obviously have very strong opinions about the death penalty and where it should go moving forward. So to start with, I'm here to tell you what you should already know as law students who are thoughtful and paying attention to the world around you, and that's that the death penalty is broken. It is a broken system. There's a lot of broken systems in our criminal justice system, unfortunately, but this one is the most broken in my view, and in the people that do this work in our view, and it's on its way out. I think pretty much across the country, people acknowledge that the death penalty is eventually going to be abolished in the United States, as it has, in all the other civilized countries around the world, and that's where it's headed. 2 weeks ago, Virginia abolished the death penalty, and that's a good step forward in my view. So now where we are is there are 27 states in the United States that have the death penalty. And that's down from a high of about 38, I think, some years back. So it's chipping away. States are just more and more seeing that it's not cost effective, that it's not economical, and basically that it's just wrong. It's immoral. And so that's where we're headed. But when you have these 27 states now with the death penalty. 3 of those states have moratoriums. That my state of Pennsylvania. I think the other 2 are California and Oregon. So you're under 25 states that have the active death penalty, but so few even use it. So we always said once it got under 25, I think a lot of us thought that that's when the Supreme Court was going to say, okay, it's arbitrary and capricious, it's random, and it doesn't have a penological purpose anymore. And some of you, if you've studied the death penalty, you know some of that framework that we look at when we're thinking about Eighth Amendment claims. But the reality is also that it's completely random, it's arbitrary. And when you look at cases, and we're going to talk a little bit about some cases today, and when you look at the cases, you could see how random it is, that one person gets executed and another does not. And why do those decisions get made? And they get made for very, very random reasons. The reality is that people end up on death row usually because they didn't have adequate counsel, or because of prosecutorial misconduct, or from hiding evidence, or for racism and things like that. It's arbitrary, so it's unconstitutional. It's racist, so it's unconstitutional. And it's also, in my view, immoral and unethical. And so few states use it that that's where we're headed, right? So you guys are all in Texas, right? And so you know Texas uses the death penalty very often, more than any other state at this point. Texas, Florida, Tennessee, and now the feds, as we've seen, have executed 13 people in the past year, the past 8 months. And so we'll talk a bit about that. But so few states use it. And the racial aspect of the death penalty is so glaring. If you look at the death, if you're interested, you can look at the Death Penalty Information Center, DPIC, we call it, and they have a great website with all kinds of information about the death penalty, and they do focus on the racial aspect of it. Rob Dunham, who runs that organization, was in our office years ago for a while, helped form our office actually a long time ago. But he's really terrific, and I remember watching him do a presentation one time where he looked at the counties in the country that had the highest rates of lynchings during our country following slavery. And then he overviewed or overlaid another map onto that map that were the counties that have the highest rates of executions. And it was stark how these counties were similar. And that's where the death penalty really is and where it's headed. And so just a real quick quote, and then I'm going to tell you a little bit about my office. I have a few lawyers who have joined us from my office, some younger folks than me that haven't done the work as long. So here's a quote from one of the spiritual advisors in the federal executions who witnessed one of the executions. He may have witnessed more than one. And following one of the executions, he was a minister. He turned to the execution team, the people, the executioners, the people who carried out the execution, and he said to them, "I would be remiss in my role as a minister if I did not advise you to find another line of employment before you lose your souls." That's guts, right? He said that to the executioners. And I thought that was just a really powerful thing. And that tells you kind of where we're headed with the death penalty, I think, in the future. So, as Kenesha said, I have been a public defender for 31 years. For the first 13 of them, I was a trial lawyer in Philly in the public defender's office. I did lots of trials, a lot of jury trials, a lot of bench trials, a lot of representation for many years. And then about 18 years ago, I decided to join the federal office to do capital cases on post-conviction. And I really, I kind of always knew I wanted to be a public defender. I think from the first day I had criminal procedure and saw the way that the accused are treated in this country, it was something that always bothered me. And so that's where I ended up. In 2008, when Obama was elected, I personally thought, and I think a lot of us thought, that within 5 years or so, we would be finished with the death penalty. And, we often talk about that in terms of career, that, we've all chosen a job where our ultimate goal is to put ourselves out of work. And that's where we are. But I'm happy to talk more about that if folks want. So I joined this office and then started doing this work. And then I became the chief of the office about 7 years ago. And we're a very big office. We have 42 attorneys in our office, and we do cases all over the country. We kind of, at one point, the Administrative Office of Courts asked us to take on some of the federal death penalty cases rather than, just the state cases. For a long time, we were really just doing Pennsylvania state cases in federal court when we're appointed by a federal judge. But over the past 10 years, we've expanded our practice pretty greatly to other parts of the country. At requests, we get appointed by federal judges in various places. And since you guys are in Texas and we want to talk about Texas a good bit today, I can tell you about kind of how that happened. We now have 12 cases in Texas, state cases. We had 3 federal cases in Texas. Also, one of our clients, unfortunately, was executed a couple months ago, who was from Texas. But we got these cases basically when we're appointed by a federal judge when they get into federal court. Texas historically did not have a capital habeas unit in the state. Just a few years ago, they formed 2 capital habeas units. One is in Austin and one is in Dallas, and they're terrific offices. They're new and starting to expand and hire new attorneys, and they're really doing terrific work. But it's extremely difficult work in Texas. Doing this work is not easy. And prior to those 2 capital habeas units being formed, we started agreeing to be appointed to some cases there. And that's how I say we ended up with 12 of them. And we're a very large office, and we've ended up in a lot of other states as well. We have cases in California and Oklahoma, and we had a case in Virginia. Now that that's no longer a capital state, that's good. We had a lot of cases in Delaware, which is now no longer a capital state, and lots of other places, some in Florida and Louisiana and Georgia and many different places. And so there's a lot of travel involved in our work. It's really fascinating going to other jurisdictions to see, to raise these challenges and see what we can do. I have 4 of our attorneys from our office are on: Hayden, Sam, Anna, and Ali. And so if you have questions for them, or guys, if you want to jump in at any point, feel free to, that's fine. And so there are, just so you know, there are capital habeas units in many parts of the country. There are 20, I think there's 28 now. So I said Texas has 2, only for the last couple of years. Florida has 2 that are very recent. North Carolina, they just formed one, and they're going to cover North Carolina and South Carolina. That's the newest. But there are, cool career opportunities in this work. There's lots of other organizations that do this work, not just capital habeas units, but we could talk more about that. All right, so let's get to the pandemic. It's been a crazy year, and I know it's been a crazy year for you guys as students. Learning remotely and not being in each other's space. It's just, it's not good. It's not good for us. It's been a really difficult year to do this work, I think, for those of us who do it. How do you be a lawyer? How do you be an effective lawyer during the pandemic? It's not been easy at all. We've made the best of it, but, our clients have the 6th Amendment right to counsel, and they have the right to meet with their attorneys and speak with their attorneys. And during this past year in this situation, we've not been able to do that. We have not been able to see our clients in person, with the exception of on several days leading up to their executions. And that's really a sad state of affairs, right? But it's also really implicates the 6th Amendment and the right to counsel, and whether or not, people that are facing an execution, especially an imminent execution, are having their 6th Amendment rights met. And so I'll talk about that in a couple minutes, because we've litigated these things in some of these cases with mixed success, mostly with no success during the pandemic, unfortunately. And that was really a result of where the U.S. Supreme Court has come on this issue. And we'll talk a bit about that in a few minutes too. But like I said, we weren't able to meet with our clients the way we normally would. In this past year, we've been appointed to, I think, 4 new cases in different parts of the country. And we have not been able to meet those clients. And that's a terrible thing for somebody on death row. We spend a lot of time with our clients. We see them usually within days of being appointed on a case. Somebody's getting on an airplane and going to meet our new client. And so that's been a difficult thing. I mean, we've made the best of phone calls, but it's no substitute for in-person representation, particularly in cases like this. These are cases at the highest level of the criminal justice system, where people are facing the most severe penalty and punishment, and not being able to sit down with them to discuss these things in person has been really, really difficult. It is also, it's also shut down investigation that we would normally do. You know, there are statutes of limitations in these cases that cause problems. People below their statute of limitations. It's happened very often in Texas that people miss a statute of limitation, and for that reason they end up getting executed because a court will not hear their claims. And so we're not able to push those statutes of limitations back, so we have to do the work. And we've done our best to do it during the pandemic, but it's been very difficult. And part of that work, especially in capital cases, is to do a deep dive of investigation into our client's life and their life history and how they grew up. And many of our clients have severe mental illness, often because of the way they grew up in severe poverty and with abuse and other things that have happened to them. And those are things that we need to do with investigation. And it's been really difficult to do that. And the other most difficult thing about the pandemic, I think, has been when executions have moved forward. And it's been completely, what I've been saying for the last several months is just how irresponsible it has been, or it was, for the federal government particularly to move forward with these executions during a pandemic. And there basically became super spreader events. In Terre Haute, where they executed 13 people, they bring in scores of people in these execution teams, outside contractors, they would call them, who would come in to do the execution, to perform the execution, and all kinds of security personnel all over the place. And I was there for the 3 of our clients' executions, and I'll talk about that in a few minutes. But Texas, on the other hand, has had only 1 execution since the pandemic started. That was Billy Wardlaw, who was executed this past summer. I think Texas had executed 2 people before March, when the pandemic really hit. And then once the pandemic hit, in some cases in Texas, the prosecution agreed to move the dates or to withdraw the dates. In some cases, the Court of Criminal Appeals, which is the highest criminal court in Texas, granted stays of execution based on the pandemic. So basically what happened is Texas executed fewer people in 2020 than it had at any time since Furman, since the early 70s. But they did move forward with Billy Wardlaw and denied stays in his case based on the pandemic. In our case, Ruben Gutierrez, who we've represented now for a couple of years in Texas, they tried to move forward with his execution. His execution was scheduled for June 16th, this past summer. And we litigated the pandemic. Up until his case, Billy Wardlaw was executed after Ruben. So Ruben was really going to be the first one to be executed during the pandemic, because all of the previous ones that had been scheduled, and there were at least maybe 6 or 7, I think, had been given either a stay of execution by the CCA, or the prosecution agreed, or they worked out some way to maybe change the date. A couple dates had been changed and pushed further down the line. But with Ruben's case, they denied that. And the question is why? Why was he treated differently than the others who up until that point had been given stays of execution, or by agreement, the other side had agreed to move their execution dates? But they wouldn't do that for Ruben. And we don't know why. We don't know why that was different. We litigated the same issues that other people had stopped the executions, and we did it in the same way, in the similar way. We sent the numbers to the court. We said, here's what the pandemic looks like in Texas. Here's why this is an unsafe procedure to move forward, why it's irresponsible to move forward with Ruben's execution. And the Court of Criminal Appeals denied that. And the prosecution on the other side refused to agree to change the date. So Ruben was treated differently. We don't know why. But part of the problem was that our investigation was shut down. In Texas, if you get an execution date 90 days out, they put that in a statute some years back to make sure that there is enough time. The reason you get 90 days, you get a date that's 90 days out, is so that you have sufficient time to do a constitutional and proper clemency proceeding. And so we didn't have that because we weren't able to travel to see Ruben. We weren't allowed into the prison to see him. We weren't able to continue the investigation that we had started that then got shut down when the pandemic hit. And we litigated that as well. We said that's part of the reason that you should not move forward with this execution, because we cannot have a fair clemency proceeding when we're moving forward in this way without being able to do those things. But the CCA said no, the Court of Criminal Appeals said no. And so they were moving forward with Ruben's execution. We had been appointed pretty late in his case. He was in the Fifth Circuit already, so he was towards the very end of his appeals when we got appointed in his case. And that happens sometimes for a variety of reasons. What happened in his case is that the attorney who was representing him needed to get out of the case for professional reasons. And so we had been asked if we would consider accepting appointment in that case, and we said sure. And so we took that. We took his case. He has now had 4 execution dates in the short time that we've represented him, which is 2 years or so. In 3 of those, for 3 of those execution dates, we were able to get them lifted one way or another because of clerical mistakes. It's really amazing, right? That you're looking at a death penalty case, and 3 times when they went to set his execution date, there were errors when they went. There is a set procedure, the way you have to do this in Texas. You have to have a sealed copy, and it has to be delivered certain places. And those are all for good reasons, for protection, so that somebody doesn't get executed and everybody doesn't know what's going on. And that's what used to happen all the time. So they put these procedures in place. And so 3 different times we were able to get stays of execution in Ruben's case for that reason. But all along, since the day we got Ruben's case, we have been asking for DNA testing. This was a case in which an elderly woman was killed in her home. They found fingernail scrapings when they did the forensics, and those fingernail scrapings exist. I've seen them myself in the box in the district attorney's office, and we've asked that these fingernail scrapings be tested against Ruben's DNA. Ruben has always maintained that he was innocent, that he did not kill this woman. And the state at one point had agreed to do testing, and then they changed their mind. This was before we were involved in the case. But now they just refuse. They say, all we're trying to do is delay. But that, our position has been, what are you talking about that we're trying to delay? We've had the case for 2 years now. And at this point, I'm going to tell you in a minute how we got a stay of execution in his case. And he does not have an execution date now. So why not let us do this DNA testing now? There's plenty of time. It won't cost you anything. We will pay for it. And we're ready to do it. So we've been trying to get them to agree to do that. They've not. We've been litigating that. We litigated it through the state court, and we're not successful there and did not get an order granting us to do the DNA testing. We're currently pending on that issue in federal district court now, and we're hopeful that that we'll make some progress in that regard and be able to get this DNA testing so that we can prove that Ruben did not kill this woman and should not be executed. But what happened in his case is we got to June 16th, and they were scheduled to execute him. And I went to Texas with Rachel, our investigator on the case, and they let us into the prison to see Ruben on the 2 days, maybe 3 days, I think, prior to the scheduled execution date. So we got to spend some time with him talking about a lot of these things, and we had this litigation pending, the DNA request pending. But Ruben was raised Catholic, and he's a devout Catholic. He spent a lot of time in prison since he has been put on death row, and he has maintained his faith. And as a Catholic, he requested that he would have a spiritual advisor with him during the execution. And this is what actually ended up stopping his execution. And just to give you a little background about Texas in this regard, is there was a case called Murphy. Mr. Murphy is a Buddhist who was on death row in Texas, and he had been scheduled to be executed late in 2019, I believe was the date. I could be wrong about that, but around there. And so he had requested that he have a Buddhist spiritual advisor in the chamber with him during the execution. And TDCJ, the prison authorities, said, no, you can't do that. You can only have one of our approved spiritual advisors, all of whom are Christian. And so Mr. Murphy took that claim, that request to the U.S. Supreme Court. And he got to the U.S. Supreme Court, and they said, you're right. You can, under the First Amendment's free exercise clause, Texas, you cannot discriminate on the basis of religion and not allow him to have his Buddhist spiritual advisor in the chamber when you would allow a Christian to have their Christian spiritual advisor in the chamber. And so his execution was stayed for that reason. And in that order, I guess the newest justice at that point was Justice Kavanaugh, and Justice Kavanaugh published a concurring opinion, which he agreed with the decision, but he said, Texas, if you don't allow anybody in the chamber, you won't have this problem anymore. He basically gave them a hint about how they could resolve this issue. So Texas took him up on that suggestion, and they said, all right, here's what we're going to do. Nobody can go in the execution chamber during an execution. No spiritual advisors. They can see the inmate prior to the execution, but not be in the chamber. And so at that point, we litigated this issue because all along, Texas has said it's fine to have a spiritual advisor in the chamber. But now what they said in our litigation was that it's a security risk. And, you know, our position was that was ridiculous. They've done this hundreds of times, that they've allowed spiritual advisor to be in the chamber during execution. So to say now that it is somehow a security risk was ridiculous. And so we litigated, we filed a lawsuit under 1983, Rule 1983 suit. And we got the Texas Coalition of Catholic Bishops, which is an amazing organization, agreed to support us with an amicus. They filed an amicus brief in the US Supreme Court. We had gotten a stay of execution from the federal district court. And in the weeks leading up to the execution, we got that stay. Several days before the execution was scheduled on June 16th, the Fifth Circuit Court of Appeals vacated that stay. So then we took that to the US Supreme Court, I think on the day before Ruben's scheduled execution. And we ended up getting a stay. I was there, and you know, it was during the pandemic. It was this past June, and it was not a safe situation. We went into Polunsky several days, where the death row is in Texas, and we met with Ruben. You know, we had masks and other people were masked and things and all of that. But, you know, prisons are incredibly close spaces. We've seen nationally around the country and in Texas as well that the pandemic has just been widespread in prisons and more so even recently because of that situation where there's no social distancing in a prison. It's ridiculous to say that. So moving forward with these executions was really an unsafe thing for Texas to do. And I was there, Polunsky, for a couple of days, and I felt the need to be there as Ruben's attorney. I got to know him over the last couple of years, and they were moving forward with his execution, and I felt we should be there. So we made that decision. We tried to be as safe as we could. And then on the day of the execution in Texas, they move you to Huntsville, which is where the execution chamber is. It's about 2 hours from, an hour and a half from Polunsky. So Ruben was moved to Huntsville, and I saw him there in the prison. I went into that prison as well, which is another unsafe situation and another reason that they should not have allowed these executions to move forward in such close quarters. And so he was scheduled to be executed at 7:00 that night. And so we were in a room waiting to go in to witness the execution with a lot of Ruben's family members who were also there. And at about 5:50, we got a call from the United States Supreme Court. So that's an hour and 10 minutes before he's scheduled to be executed. I got the good call from the US Supreme Court. We don't often get the good call from the US Supreme Court in these situations. So that was a very happy moment for his family, for us as his attorneys. And I was able to be on the phone with Ruben to give him this news. He was only a few feet from me, but I was not allowed back in there to tell him this, but they did allow a phone call with me. And so we could tell him that. And so what does that mean now for the death penalty in Texas, or what impact does this have? And that's a good question. We don't know the answer to that. What the US Supreme Court did is they stayed his execution, and then they asked the lower court. The district court had granted us a stay, but had not, the proceeding was at an early stage. It hadn't moved forward with a trial or with discovery and all of those things. So Supreme Court asked the district court to conduct discovery and make findings of fact and conclusions of law and send them to the US Supreme Court. So we did that. We went back to the district court, we did depositions, we did engage in discovery with the other side. And the court then issued findings of fact, conclusions of law, and concluded that we should win under the First Amendment and sent that to the US Supreme Court. Then the US Supreme Court more recently granted certiorari and sent it back to the district court for further proceedings. Well, back through the circuit court and then back to the district court. And that's where we are now. So it's going to be moving forward, and we may have a trial in district court, and we'll see where that ends up. But what does that do, more broadly? So Alabama was scheduled to execute someone about 3 weeks ago, maybe 4 weeks ago. And this issue came up because they had this similar situation where they would not allow a spiritual advisor in the chamber. And so the Supreme Court stayed that execution, stopped that execution in Alabama. And then what Alabama has done since then, in the last several weeks, is they changed their procedures so that they will allow a spiritual advisor in the chamber. Texas has not done that. We don't know what they'll do, but we'll see as we move forward with this litigation in the lower court on this issue of the spiritual advisor. But the good news of that is that, Ruben's still alive. He still maintains his innocence. We still have this push for the DNA. We're still asking the district court to rule in our favor and order that the DNA be tested. And we're still going to continue those efforts. But that shows you right there how arbitrary and random the death penalty really is. That Ruben ended up getting a stay within an hour of his execution on this issue that had very little to do with his case, but was an important issue nationally. And then that's where we are. But Billy Wardlow, on the other hand, did not raise this issue, and he was executed. And so, that disparate treatment of people is why the death penalty is really, really arbitrary and random. So what's next for Texas in the death penalty? As I said, this is the fewest executions in any year since Furman in 1972, in the 70s and the wake of Furman. So, but Texas has, this was based on the pandemic that they did so few executions. We haven't seen any movement that Texas is moving in what I would consider the right direction on this issue. There are 4 executions currently scheduled now in Texas. There is one in April, one in May, one in June, and one in September. And we also know that in Texas, they are seeking some dates in some other cases. But we don't think that Texas is easing up in this regard, in the death penalty, and we'll see where this goes in this regard. In fact, I read something the other day that there's a bill pending in Texas that anybody who gets or seeks or performs an abortion should be subject to the death penalty. So it doesn't seem that Texas is going to be easing up in the death penalty in any way. And that's unfortunate. There are, these race issues that come up in death penalty cases are very, very prevalent in Texas in these cases. We have a case currently in the Fifth Circuit Court of Appeals, a Texas case in which our client's lawyer during the penalty phase wrote a note on a piece of paper that said, "Can you say justifiable lynching?" About his own client's penalty phase. And like, what does that tell you about the state of the death penalty in Texas when that's the kind of thing that happens? And we are currently appealing that to the Court of Appeals. Dallas is trying to set execution dates for 2 men, including one of our clients, both of whom are Hispanic, when there are, I believe, 13 white people on death row out of Dallas who have been on the road longer. Why they picked these 2 Hispanics, I don't know, but that's something that we're going to be raising. And there are lots of Batson issues. We know, you've probably studied about Batson, that when people exercise peremptory challenge in a racially discriminatory manner, that's unconstitutional, and your conviction gets reversed. And we see these in lots of cases. So that's the future of the death penalty in Texas. I think it's going to go back to the status quo pre-pandemic, and that's where the fight is going to continue. So let's talk for a couple minutes. I haven't seen any questions yet. I don't know if I hope I didn't miss any hands, but if I did, I'm sure Kenitra will tell me. So let's move on to federal executions and what has happened there. And what does that mean? What does that mean for the future of the death penalty? And kind of what happened. I think it's important to be a witness to what happened. I was a witness to one of the executions. My client, Dustin Hunkin, was executed, and I watched him be executed. It was not an easy thing to do as an attorney. We had two other clients executed in Terre Haute in these federal cases, and we had attorneys also witnessing those executions. But let's back up and talk a little bit about what happened so you know, because it's historic what happened in the United States last year. They executed 13 people in 8 months. That has never happened before in the United States. I mean, since like the 30s, maybe 20s, long time ago, 100 years ago. Initially, so there had been a 17-year hiatus since the last federal execution. And that was for a couple reasons, mostly because there was litigation pending in Washington, D.C. regarding the method of execution, what we call a lethal injection challenge, right? They pretty much use lethal injection in most places now, although I heard the other day that South Carolina is trying to make the electric chair in the firing squad the main method of execution, which is just really moving backwards, unfortunately. But lethal injection has been the main way that executions have been carried out. And there was this litigation that had started years and years ago and had been sitting in federal district court in Washington, D.C. for many years. During the Obama administration, they did not try to move forward with any executions. And that litigation pretty much stayed there. They did not have a protocol to perform the federal executions. And so when Donald Trump got elected, we figured they're going to start moving forward with these. We didn't realize they were going to do it in such a short time and kill so many people in such a short time. But that's what it was. So they had initially scheduled 5 back in the fall of 2019. They said, okay, we have a new protocol. And the same day they issued the protocol, they scheduled 5 executions, including for our client, Dustin Hunkin. And those were scheduled in December of 2019 and in January of 2020. And so, but that lethal injection litigation, which had been sitting for a decade at that point, then got re-upped, and more people filed complaints, and they were all consolidated. There were about 14, I think, plaintiffs in that consolidated litigation. And my office took a lot of the lead in that litigation. The first 5, as I said, were scheduled between December and January. And also our client, Alfred Bourgeois, was scheduled then. He was one of the 5. So Dustin Hunkin and Alfred Bourgeois, both of whom we represented, were in that first 5. We were able to get a stay of execution in the federal district court in Washington on the basis that the government had sat on their hands for many years and then all of a sudden said, here we got a protocol, now we're going to execute people. None of the discovery had been complete. None of the proceedings had been complete in that litigation. And we got the federal district court granted a stay of execution, and the US Supreme Court left it in place over several dissents, but they left it in place in December of 2019. So those executions did not move forward at that time. But then they started to reschedule them all beginning in July because that litigation moved further along. There was discovery, there was depositions and other things that happened. So the government said, okay, now we're going to start scheduling these again. And so they scheduled 3 men for July, and then started scheduling others as they moved forward. And there was no rhyme or reason really to who they picked and why they picked. We tried to litigate that to get information about that, but that's part of the randomness of this is why did you pick this person rather than this person? They didn't do it in a way that they picked the people that had been on the death row the longest, which they could have done. And maybe that would have been the most fair way to do it, but we could not get any court really to say that the randomness there made it unconstitutional, though we tried. And, when I look back on this, ultimately they executed 13 people. And once July started, and they started these executions in July, nobody was getting saved. Nobody's execution was getting stopped. And you know, when I look back on it, it just jumps out at me. And to some extent, you know, I feel so foolish because every time another one of these executions came up, I thought, okay, this one, there's no way they can move forward with this one. Look at all these equities. Look at all this stuff. But it did not matter, unfortunately, to this court. They were moving forward with these 13 executions, no matter what happened. There were clients who were intellectually disabled. There were clients who were so psychotic that they were forward incompetent. That's the name of the case that says you can't execute someone who is so psychotic that they don't know what they're being executed for or why. There were people in that camp. There were people with Brady violations, prosecutorial misconduct, of hiding evidence, of snitches and things like that. There were even innocence claims. And throughout it all, there were redemption stories. And redemption stories are important to clemency and for reasons not to move forward with these executions. But that was just not happening. They were not stopping these executions. And every time another execution came up, I remember, you know, I'd be sitting somewhere watching. We were doing Zoom meetings and all of that with our colleagues. And I'd be sitting there and thinking about them like, they're never going to move forward with this one. But every time they did, they just went forward with all of them. And let me just give you a quick list of the people that they executed. These were people that had families and were loved. I know the victims' families in some of these cases were very much in favor of execution. In others, they were not. There were cases in which the victims' families came out and said, don't kill someone in my name. And the courts, they were litigated in courts, and the U.S. Supreme Court basically lifted every stay that was in place in all of these executions. Danny Lee was the first one executed, and I'll talk about that situation in a minute. He had, in his case, the victim's family came out very clearly and said, we do not want him executed. It was also during the pandemic that they argued that, and he ended up executed. Wes Perkey was very psychotic and forward incompetent. They executed him. Our client, Dustin Hunkin, we had the lethal injection litigation, and his was really a story of redemption that I told in the press after his execution. There was no reason for him to be executed. Lesmond Mitchell was a Native American. The tribe objected to his execution. The courts did not stop that. Keith Nelson was another person who was young, pled guilty, and another redemption story. William LaCroix was a soldier who was severely psychotic and thought it was witchcraft that was killing him. Chris Vialva was a very young man. He had Batson issues. He was tried by an almost all-white jury. Orlando Hall was intellectually disabled, should not have been executed. Brandon Daniel was 18 years old. He was the prosecutors in his case asked for clemency in his case, which was denied and never ruled on, actually. Our client, Alfred Bourgeois, was intellectually disabled. He had IQs in the 60s. You're not supposed to execute people with IQs in the 60s. He was executed. Corey Johnson was also intellectually disabled. Lisa Montgomery is probably the one you may have heard the most about. Hers was very notorious case. Ms. Montgomery was severely psychotic, had no idea where she was, why she was being executed, and they moved forward with her. And our client, Dustin Higgs, never killed anybody, a very strong innocence case, and he got executed. But as I said, like any one of those 13 people, under normal circumstances, you would think that the court would step in and stop those executions for those really significant legal and constitutional reasons that they should have been stopped. But they weren't, because it was just a roller coaster that these were moving forward and they were all going to be executed. And that's what ended up happening. And most of these cases were 6-3 in the U.S. Supreme Court, 5-3 until Amy Coney Bryant came on. Then they were 6-3. But routinely, they stopped. I'm sorry, Khadija, you wanted to say something?
Oh, no, you have a hand. We have a hand from Lindsay Rojas, but I do have questions when you're ready. We have a hand.
Okay, good. Go ahead, Lindsay.
Hi, Mr. Nolan. Thank you so much for being here today. I'm a 2L at SMU, and I'm also a Deason scholar with the Deason Center. So I was really excited to hear that you were coming to speak with us. I just had a quick question. I shared a story in one of our staff meetings about a month ago on Raymond Riles, how he has been deemed mentally incompetent, so he can't be executed. I know you were mentioning how like arbitrary the death penalty is, but you've been mentioning people who are also mentally incompetent are still being executed, at least from what I've understood you saying. So I guess my question is, where, like, I know it's up to the state to make that determination, but when, like, is there any like any general standard of like when it's too far? And then on that, why do people who are believed to be mentally incompetent or are mentally incompetent, why do they stay on death row?
So I guess there's two kind of, competency is a complicated thing, right? So there's competency to be tried, which is a little different than competency to be executed. So if somebody's not competent to be tried, they should typically be hospitalized. That's usually what would happen. But in the realm of the death penalty, competency to be executed is a higher standard, which is that you don't understand why you're being executed, is the easiest way to put it. So if someone is deemed forward incompetent, it's called Ford is the name of the US Supreme Court case, so you can have a look at that and see. When somebody is deemed forward incompetent to be executed, they can't move forward with the execution, but they stay in prison. So we have a client in Pennsylvania who this happened to. They were, before we had our governor impose a moratorium, they were trying to move forward with his execution. And we challenged it on that basis, and we did an evidentiary hearing, and ultimately he was found to be forward incompetent. He's still in prison. He's still on death row. His conviction has not been vacated, but they cannot move forward with an execution of him. There is the possibility in some of these cases where someone could recover competency to a point where they're no longer forward incompetent, and then they could still move forward with the execution. So that's to answer the second part of your question. That's what the standard is. It's a little bit different in terms of, so some states have started to look at this. Ohio passed a statute very recently saying that you cannot sentence somebody to death who is severely mentally ill. And so then in the statute, they write, what do you mean by severely mentally ill? And there's definitions and things like that. And then that will be litigated going forward. We have 2 cases in Ohio, and we're going to have a look at that and see whether that's something we want to litigate going forward. Does that kind of answer your question?
Yes, thank you.
Sure. So let me go back just a little bit, and then we'll open up widely for questions. I think, I was talking about the U.S. Supreme Court. They vacated all of the stays. In many of these 13 executions, people had stays of execution in place on the day of their scheduled execution by lower courts, some by the circuit courts, some by the circuit courts in Washington, D.C., a number of them from the Seventh Circuit. The Seventh Circuit is where the federal death row is in Terre Haute, so that's in the Seventh Circuit. So some of these litigants filed claims that ended up in that circuit through the district court there. Some had stays in place in the district courts that got vacated by the circuits, and then the Supreme Court refused to reissue the stay. But in every one of these cases, people had stays of execution in place at some point, every one of them. And the US Supreme Court either vacated them or did something else to allow these executions to go forward. The first week that these executions happened was really a stark week for us as capital litigators, and in my office especially. There were 3 executions scheduled that week: Monday, Wednesday, and Friday. That's what the federal government was doing. They were scheduling these because they had these, I said this earlier, they had these outside contractors come in to do the executions, and they wanted to pay them for 1 week at a time. So and they put this in like answers to pleadings that, they couldn't change the date of this execution because they'd have to pay these outside contractors more money. It seems insane to me but that's the way they argued that. And so this first week, it was Monday, Wednesday, and Friday. Danny Lee was the first one executed. he had several stays in place on that Monday that lasted late into the evening, one of which was a lethal injection stay that applied to all of these people that were scheduled. Because I said there were like about 14, I think, consolidated plaintiffs in that litigation. So that also applied to our client, Dustin Honkin, who was executed that Friday. So these stays were in place. And so we got past midnight that day. It was Monday. And I remember sitting in my living room watching, and we were on Zoom calls with our lawyers. We didn't represent Mr. Lee, but colleagues, very close colleagues of ours did. And we were involved in consulting on the case. It got past midnight. And so at that point, in Texas, for example, if the litigation passes midnight and they haven't resolved it, the execution warrant expires at midnight. And so then in Texas, they would have to wait another 90 days to set a new execution date. The federal government hadn't executed anybody in 17 years, and there were no regulations in place that explained anything like that. So it got to be midnight, and we thought, okay, we're safe. They can't execute him on Tuesday because his execution date was scheduled for Monday. But that wasn't the case. Around 4 a.m., the US Supreme Court finally ruled and vacated the stays that were in place in that case. And then Mr. Lee was executed around 8 a.m. And what the Bureau of Prisons said is that, well, we don't have to give him a new date. We just have to give him notice that we changed the date. So they gave him notice, in the middle of the night that they changed the date to that day. And then they executed him on that Tuesday morning around 8 in the morning. Wesley Perkey was scheduled to be executed on that Wednesday. He also had a number of stays in place, one from the Seventh Circuit, I believe, and also in Federal District Court in Washington. The US Supreme Court vacated his stay in the middle of the night also, and he was executed that next morning, Thursday morning. Again, they gave him notice that we've changed your date within an hour or two of his execution. And our client, Dustin Honkin, was scheduled to be executed that Friday. And we were scheduled to see him that morning, and we were able to get in, but it was a very complicated situation because they were still in the process of executing Mr. Perkey at the time that we were supposed to go see Mr. Honkin. And so our visit got delayed, and it's the last visit before he's being executed. So it's obviously an incredibly important visit for us to have. And so his stay had been lifted the day before, and it got to be Friday morning. And Dustin did not want to be strapped to the gurney for 4 hours the way Danny Lee was earlier in the week. So, we had some other avenues that we could have tried to stop his execution on that day, but he did not want us to do that. And so it moved forward. His execution moved forward. I witnessed it. I watched him die by lethal injection. It was a pretty horrifying experience to watch. And then I flew back to Philadelphia. It was a very strange situation. The guards who drove us back to our cars as they dropped us off after watching Dustin be executed told me and my colleague to have a nice weekend. I thought that was a little crazy, and kind of tells you the mindset of what was going on during these federal executions. Go ahead, Khadija.
Shawn, because the Supreme Court removed all these stays, and I'll admit this is where my ignorance starts. If they provide any reasoning, and if they did or if they didn't, does that mean that case law and those protections for future federal and state executions are removed? Like you said, you aren't supposed to execute people who have a certain who are incompetent or who are currently unable to understand why they're being executed. You're also not supposed to execute people with an IQ below a certain number. So these are protections against this kind of behavior that were basically removed when those stays were removed. Does that mean that going forward that case law is muddled? Are
Yes.
you still going to be able to argue those same?
Yes, we will still be able to argue those things. But yes, the simple answer to your question is yes, the case law is muddled because they did these things in a rush in the middle of the night to vacate these stays. And so what happened in some of these cases later, like some of the cases that happened later on, so these these executions all happened between July and January. And in some of the later cases, in the late fall and in the early winter, the government would be arguing, look, here's what the Supreme Court did in Danny Lee, and that's why you should move forward with this execution. So yes, it got extremely muddled. And in some of the cases, and very often they would vacate the stays and say nothing. The U.S. Supreme Court. They wouldn't say why. They just would say per curiam, stay is vacated, and it can move forward. And so in the first one, in Danny Lee's case, they issued a short opinion about the lethal injection litigation. And as I said, then the government used that short opinion to argue against some of the rest. In the cases that have to do with intellectual disability, low IQ, and forward incompetence and things like that, the Supreme Court said almost nothing. So it's unclear what that means in terms of precedent. We know that the government will argue that those executions went forward, so these protections are now less than they were, and we'll fight about that. But a lot of times those will end up being factual questions. I guess we'll see.
There's a question in the chat from one of our staff members and a current law student. She says, you discussed significant intellectual and emotional challenges to being a capital habeas attorney. What are some of the most rewarding aspects of your job?
Yeah, I know. I'm really sorry, because I know I'm up here like telling all these horrible, sad stories, but and that's because that's the way this year was in so many ways, I think, from the pandemic and others. But it's an awesome job. It really is. And maybe some of my colleagues will jump in too. It's extremely rewarding. This past month, we've had 2 clients released from prison after spending decades on death row. And they got out of prison, and our lawyers went to the jail and picked them up and took them to the Wawa, which is the local convenience store in Philly that sells hoagies and food. And so it's incredibly rewarding. And and so those things happen to us, and we've had many, many successes in our office. I mean, Pennsylvania has not executed anybody since 1999. And the biggest reason for that is because our office has had a lot of success, and there's 2 other offices in Pennsylvania like ours. And we've had a lot of success litigating these cases and been able to stop executions. We had a client come within 2 hours of execution in Pennsylvania in 2012, and we were able to stop his execution at the last minute. So that stuff is incredibly rewarding and makes the job really, really awesome.
So there's been some questions about how difficult it is to litigate actual innocence claims, especially when we're looking at what's happened in Texas sometimes with our execution sprees. Can you speak to the difficulty with that? You alluded to it earlier when we were speaking about Ruben Gutierrez. He's maintaining his innocence, and it's hard to get them to actually test DNA. Can you talk about how hard it is to litigate those types of cases around the country, or is Texas just an anomaly in that sense?
No, it's hard all over the place. I think that the DNA case, which is what's surprising to me about Ruben's case, is that they won't just agree to test the DNA because it's there, right? And the DNA cases are the ones that there are innocence projects around the country, and they're usually looking for DNA cases to take because they're the ones that you can actually prove. You can prove definitively whether somebody did a killing or not, rather than many times there are innocence cases where there's no DNA involved. That happens far more often than cases where DNA is involved, because if you think about it, people don't leave their DNA around in most cases. Most capital cases, majority of them are shootings. There's no DNA involved in those cases. So those, and a lot of times we have innocence claims that we litigate that are based on witness testimony or snitch testimony that was recanted or things like that. I had a client executed in Delaware some years back, and I completely believed he was innocent. And we investigated the case, and we found all kinds of people who said there was a co-defendant, that the co-defendant is the one who did the killing. He confessed to it repeatedly, told all kinds of people, but there was no DNA in that case. And so trying to get a court to accept that evidence to reverse a capital conviction is not an easy thing to do. So no, I don't think Texas is an anomaly there. I think that's true across the country.
We've got another question in the chat. The question is, you mentioned earlier that there was a stay on lethal injections. Do you deal with challenges about specific means of execution since some states still have many options available?
Yes, the answer is yes. And so in like I said, in South Carolina, they're talking about the electric chair, bringing the electric chair back, and firing squad. And so there will be challenges in that regard. Tennessee electrocuted 2 people last year. And there were challenges brought to those methods of execution as well. And, you know, the electrocution cases, the electric chair, there's so much evidence how torturous that kind of a death is for an inmate. And so they tried to litigate that in Tennessee leading up to those 2 executions unsuccessfully. But those things are going to continue to happen in other parts of the country. So yes, other methods of execution are challenged. In Delaware, we had a challenge to lethal injection, and the statute said if you successfully challenge lethal injection, you shall be hanged. Trying to bring back hanging. It's crazy, right? And so that was something we were prepared to challenge, but ended up not going forward. So we have about 15 minutes. I thought it might be, you know, as I said at the outset, there's a couple of lawyers from my office, you know, who have joined us more recently. And if you have questions for them about, you know, how they ended up here, what it's like, they're happy to chat.
I mean, I'll start off with them. Your bio, and you say you have some pretty young attorneys, say that you've been in capital habeas court cases since the start of your career. In Texas, for example, as a criminal defense attorney, you can't touch a capital case until you have a certain amount of hours practicing. How does that work in the federal public defender's office? How did your attorneys get started, or how did you get started so early in post-conviction in capital cases?
Well, I did trial work for 13 years first. So I had a good bit of experience before I started doing capital work. I don't know, do one of you guys want to jump in and talk about that a little bit?
Yeah, just my career path in general, I guess. I got started interested in public defense work, working at a federal public defender's office in Seattle, and really liked the clients. But one of the cases that we had there was a death penalty case, and I found it really challenging. I found it really kind of a unique relationship that I got to form with the client and with the other attorneys I was working with. And that was sort of the first taste of it that I got. In federal court. It's not quite the same practice requirements. We can work with attorneys like Shawn and other attorneys who have been doing the work a little bit longer, which is a nice way to get introduced to it, because I'm younger and haven't been doing it as long. And there are Anna and Ollie and Hayden who can also talk about their experience. So that was sort of how I got into it. I'm definitely the newest, though. This is like my 3rd week, so don't listen to me.
Well, in terms of how we maybe do our work, you know, at least in Pennsylvania, as any attorney, there's CLE credits, and so there are capital specific ones, and so there's certain requirements about capital credits. But also, you know, it's a large office, and we have the opportunity to work with many attorneys like Shawn and people who've been practicing for many, many years and under their tutelage. And so, you know, I think it would be an issue if someone like ourselves, who only had, you know, a year or 2 or 3 years of experience in this kind of line of work, or lead counsel in one of these cases and just doing it completely by yourself. But our office staffs large teams on each of these cases, several attorneys. You know, there will be decades of experience between us. We'll have investigators, we'll have paralegals. So there's easily, you know, anywhere between 4 and 8, and then even on late stage cases, as many as I'd say even 15 lawyers and other people on cases working actively. So that's kind of how we tackle these things. It's never a solo kind of project.
Hey everyone, I'll just say quickly how I got into it. I interned at the CHU when I was in law school, and it was just the best summer ever. And I got to work with so many attorneys and investigators and paralegals and legal assistants who were all just so committed to the work and dedicated, and had such great relationships with the clients. And they were often long-term relationships with the clients just because of the nature of the work. So all of those things really appealed to me. And then also just the office itself was so great and collaborative. And so I basically just tried to get back here any way I could after law school. So it took a couple of years, but I made my way back.
And Hayden, who is our other attorney, was a paralegal with us for a number of years before going to law school. And now she just recently made her way back too.
When I was a paralegal at the office, I was trying to convince myself out of becoming a lawyer and was taking night classes to become a nurse, but slowly lost that battle, and I'm really happy that I did. Just a random thought about the conversation about what's the most rewarding part about this job, and it's something that it can be hard to think about when you're doing death penalty post-conviction work. What's rewarding about that? And I think Shawn touched on it a little bit, but one of the things that I find really meaningful is getting to tell the stories of our clients as fully formed human beings. I mean, so much of the media paints our clients as these one-dimensional monsters, and it's a real privilege to be able to paint a picture of a human being with a family, with a history, with a story of how institutions failed them. And I feel like that is both incredibly rewarding and really meaningful. And I think it sort of reintroduces our humanity back into the picture as a society, to be able to tell those pictures of people that society is willing to sort of throw away in the most sort of permanent and irrevocable sense.
I mean, I completely agree with everything Hayden said. It's not something I was really aware of until I really started doing this work, how one-dimensional the portrayals were. I don't think you really think about it until you do this work, and then you realize there's this, of course, these clients, they have families, they have people who love them, and a lot of this work is, and then sometimes people don't have that, support, and oftentimes we can provide that support when they're sitting in solitary confinement for many, many years. Oftentimes we can kind of step into some of those roles. I did realize I didn't say my background. I started off at law firms, and so it's a bit different. I was doing civil practice. I was an employment discrimination attorney, so I defended companies who were sued for gender and race discrimination, and I did not like that line of work. It didn't really taste right, particularly because of the racial dynamics for me as a Black man defending companies who were sued for race discrimination, usually by people that might look like me. And so my goal was to save up enough money to switch and do this kind of line of work, and I focused on that exclusively, and 5 years later I was able to do that, and I saw a job opening in this office, and I'm very glad I took it, because it's a unique job, and it's a very rewarding line of work, and there's nothing that you can really do to replace the interactions and the meetings we have with our clients, and really understanding how they got to where they are, and trying to help them, because a lot of people don't care.
Thanks. And just so folks know, we have a very robust internship program, and a lot of the lawyers who ended up in our office working with us started as interns at some point. And the capital habeas units around the country all do this. We talk all the time about internships. I know all the other heads of the offices, and we talk a lot about it. The two that are in Texas have very also robust internship programs. So if it's something you're interested in, there are avenues, and I'm happy to talk further about that stuff to anybody who's interested.
Are there federal public defender offices that handle cases that aren't capital?
Yeah.
I mean, in post-conviction work.
Yes. So
getting sentenced to life without parole. Federal government, there is no parole in the federal prison system, but who've been sentenced essentially to life, but it's not necessarily a capital case. It's probably a mandatory minimum issue.
Yes, so a lot of our office has what we call the non-capital habeas unit. So we're the capital habeas unit, but we also have a non-capital habeas unit, and they represent people that are mostly lifers. Pennsylvania has one of the largest numbers of lifers in the country because we had life without parole for so many years, as opposed to Texas, who instituted it more recently. But yeah, so a lot of the offices do that, and a lot of the other federal defender offices have similar units, or even if they don't have those units, they take those cases on habeas when they get appointed and handle those cases. A lot of the state post-conviction stuff is handled by local public defender offices, and sadly, they're not sufficiently funded a lot of times to do the work as well as they could if they were better funded. But yeah, those things exist too. But I mean, we focus on the capital cases, but I think all the time that there are so many lifers out there that have just been discarded by the system, that don't have the opportunity to sometimes have attorneys, with the resources and commitment that we have. It's sad.
And we're just about out of time, but I have one more question. If the federal government, if this administration moves forward in the dream of all dreams and abolishes the death penalty at the federal phase, what does that mean for the cases that you guys have on your federal docket? And will you continue to take those cases that are in state courts?
Yes. So what it means to the federal cases is that, once we're appointed to represent somebody, we represent them till their case is over. So if for example, if President Biden commutes the sentences to life without parole rather than death sentences, we would continue to represent them in their guilt phase claims or issues moving forward. And yes, I mean, the states, if the federal government abolishes the death penalty, I think there are 2 bills in Congress right now in that regard, that's not going to impact states that are still seeking death sentences, as you know. So those will continue, and we will continue to take appointments in those cases as needed.
All right. Any last words?
So, I think I would suggest that you read Justice Sotomayor's dissent in the Dustin Higgs case. That was our case. It was the 13th execution. It was the one that I kept telling myself, they're not going to kill him. And I was wrong. But Justice Sotomayor wrote an amazing dissent that really takes to task the government for its rush to killing all these people, and really takes to task her own court for allowing it to happen. So have a look at that. Just Google Sotomayor and Higgs, and you'll see that dissent come up, and have a nice read.
I want to thank Mr. Nolan, Ms. Baldridge, Mr. Wright, Mr. Welch, and I can only see Hayden's last name, Ms. Nelson. I thank you all so much for coming and talking to our students and some of our other guest students from other law schools across the country. I thank you guys for coming and talking to us about your work in the Capital Habeas Unit, your work in this pandemic for the past year, and talking to our students about how they can get involved with doing capital habeas work or post-conviction work as they are students and when they graduate. So thank you all so much for your time. We appreciate you taking the time out to come and talk to us and give us some insight on what the future of capital habeas work looks like. So thank you all so much.